This segment is sponsored by the Suriano Law Firm.
Well, you know, this really is an unprecedented time for not only our community, but for our court systems as well. Issues are rising up when it comes to parenting schedules. To give us some helpful suggestions, we're joined again with Miss Susan Suriano. How are you doing, Susan?
Fine, thank you for having me again.
So a lot of people might not realize that when it comes to custody of a child, this is a time that they've never been through. So starting off, how are schedules being enforced right now?
So the Central Ohio courts have pretty much been consistent in the fact that they're enforcing parenting time orders.
Okay.
And particularly Franklin County. The judges across Franklin County have said you're supposed to be following your parenting time orders.
And if one parent says they don't think it's in the child's best interest to follow those certain orders or schedule, what happens then?
So the courts are really encouraging parents in this unprecedented time to really be collaborative. Sometimes those relationships are tough, but you know, you're working towards your child's best interests. And so the parents have the ability to make decisions for their child and change around the schedule, you know, do things that we need to do because of the pandemic, because of school schedules, because of work schedules now. They have the ability to agree. If they can't agree, then the courts are encouraging the next level is to maybe try mediation. Try to engage your counsel. If these parties had counsel before, call them up. I get calls all the time, and I try to help these parties come to an agreement on their own before having to file. But if they have to file, then the courts will intervene. I think the important thing to understand, though, is that if they're going to file a motion to modify their parenting plan, all the same rules still apply. So they have to, you know, think about, has there been a change in circumstance? Is this in the child's best interest? And they have to have that evidence to present to the court in order to make those arguments.
Wow. Again, what a tough time for a lot of families. And like you said, the best thing is to come together. One thing tearing a lot of people apart right now is the decision to send kids back to school or do it virtually. What happens if both parents want to do something different?
It's tough. It is really tough right now, and we've never seen this before. I'll be frank with you, if they have not filed a motion to get themselves into court, they're probably not going to get into court before this decision needs to be made. So again, focus on collaboration, focus on trying to meet in the middle. If they can't, they can file the motion. The reality of the situation is, though, is that the child's going to have to start in some direction. And the court could make a decision later on to switch that child and say, well, this isn't going to be in the child's best interest, and make that switch. But the courts, again, they're really focusing on parents trying to make those decisions together, just because the timing is so difficult, and you know, the courts have to take time to get them through the docket. So
makes total sense. Now, when it comes to child support, is that still being enforced right now? How is that working during the pandemic?
So just like the parenting time orders, child support is also being enforced. Now, if a parent has lost their job due to COVID or COVID-related issues, that's going to be a reason for a parent to present to the court about a reason that they are unemployed, don't have those means to make that child support payment, and they can present that as evidence. They also could file a motion on their own to modify child support, bringing up those reasons. However, if they don't file a motion and they're not in court, then the CSEA is going to continue to draw that support, going to continue to rack up those arrears. So it's important to be proactive about that so that you don't end up with a huge arrearage at the end. But those orders are still going to be enforceable.
Wow. And say those orders are not being upheld by the other party. One parent is just not trying to work together, not trying to mediate. Can contempt action be enforced?
Yes.
Okay.
So as we just discussed, the court order is the court order. So if there is a violation of the court order, then the other party can file a motion, bring that before the court, and then the parent who is being accused of the contempt can bring the defense before the court, and they can try to get it resolved that way. But the bottom line is, if there's a court order, there's a court order, and you need to follow it.
And hopefully a lot of parents realize that it shouldn't get to that point. Going back to what you said earlier, what is your best piece of advice for two parents to just put aside the differences and come together for their child?
So they need to take a deep breath. They need to put their emotions aside and truly look at it as, what is in the best interest of my child? What should we be doing for my child? Even if it's inconvenient for me or difficult, what do we need to do for this child? Because that's what the court would look at. And so the court's not going to solve all the problems. The parents really need to come together and try to make a decision for their child.
Well, I know you're an expert in this field. You are here to help. For people watching, if they do want to reach out to you, contact you to help them in their situation, how do they go about doing that?
Sure, they could visit my website, which is thesurianolawfirm.com. And they can also give me a call at 614-944-5773.
Perfect. Thank you so much for answering these questions. I know a lot of people have been dealing with this, always coming with the great information. Thank you, Susan.
Thank you so much.
Like she said, if you want to find out more information or to contact Susan, just visit their website, thesurianolawfirm.com.